A very warm welcome back to MJuris. Today we are going to start with the Code of Wages. To begin with, the Code of Wages 2019 is yet to come into force. It has been stated that the date will be notified by the central government. They've also retained the option of notifying parts of the Code of Wages on different dates. So this has to be something which has to be weighted and seen as to how we are going to actually have this Code of Wages come into force. So let's start looking at a few things, a few changes that have been made in the Code of Wages. For a start, there is the definition of a contractor. The first part of the definition is a very normal portion which has been there from a very long time. And it says that the contractor in relation to an establishment means a person who undertakes a given result for the establishment. So this was already there in the earlier definition of a contractor. Other than a mere supply of goods or articles of manufacture to such establishment through contract labor. So this, there is no change. But then there is an addition of a phrase, mere human resource. So let's see how this definition has been brought in. So section 2F subclause 2 says supplies contract labor for any work of the establishment as mere human resource and includes a subcontractor. Well, of course, the portion that a subcontractor is included has always been there, but apart from the contract labor being supplied to an establishment, the addition of a mere human resource has been made. So let's try and understand what is a mere human resource. Mere adds a lot of meaning here, as in there is a mechanical lending of labor, and according to me, this is going to bring in a lot of scope for interpretation by the courts, and we might see some disputes coming up in the near future. But of course, these kind of phrases, unless amended, have very wide meaning, and unfortunately this section doesn't provide us with an explanation as to what exactly the Parliament intended to bring out with this phrase. Then we have the definition of contract labor. Section 2G talks about contract labor, and there is a change in this definition, as in they state that a worker who shall be deemed to be employed in connection of the work of an establishment. So there is a deeming provision which has been brought into force. And let us understand what the meaning of deemed is in terms of a legal angle. So in the case of Rishabh Agro Industries, the Supreme Court said the word deemed used in the section would thus mean supposed, considered, construed, thought. This is the main phrase, taken to be or presumed. So this is the meaning of who shall be deemed. So when does this happen? So that is the next question. So when does a worker get deemed to be contract labor? So we are talking about when he is hired in or in connection with such work by or through a contractor with or without the knowledge of the principal employer. So we are looking at the employment of labor with or without the knowledge of the principal employer. So there's a presumption that the moment he is employed in or in connection with the work of a particular establishment, he is going to be deemed as a worker. Now, what is the consequence of this? The consequence of this is the burden now falls on the employer. So he is already deemed to be a contract labor, and to prove otherwise, the burden is on the employer. Now, apart from this change in the definition, we have the inclusion of an interstate migrant worker. And when it comes to exclusion, there are certain exclusions given to this phrase, and it's very differently worded. It says, but does not include a worker, and then within brackets, other than a part-time employee. So a part-time employee is not in the exclusion of the definition, but falls within the inclusion part of the definition. Now let us have a look at what the exclusions are. So the first exclusion is when he is regularly employed by the contractor for any activity of the establishment, and the employment is governed by standard terms of employment, and this includes engagement on a permanent basis. So this would mean that many employers who have a labor force permanently appointed by them and who are lending human resource to other establishments as contract labor would get excluded from the purview of the definition. Now, the second exclusion is a person who's also getting periodical increment in his pay and who has a social security coverage, which would be a provident fund and ESI and other welfare benefits. And it is stated that those welfare benefits must be in accordance with the law which is in force at the time being. So that is an important factor which has to be kept in mind. So these are the exclusions. So for example, if you have a security agency who have several security guards who are included as their employees, and they are sending these guards to various companies, then this would be an exclusion and they wouldn't be treated as contract labor. So this has an impact even on Provident Fund, because we've seen several cases coming up before the Provident Fund Commissioner in terms of principal employer's liability and contractors' liability, etc. So even this has to be examined in that angle. Of course, subsequently we will be getting to that. So thank you very much for watching this video. In our next video, Mr. Ananda Krishnan will be covering some more topics, and he will also touch briefly the definition of interstate migrant workman, because it has been referred to in our definition for contract labor. Thank you so much.